Yo, it's JP. I'm going to talk about the EEOC process because it seems like a lot of folks are still very confused about what the EEOC is and what the EEOC does. Okay. So if you are in a position where you just got fired, you got demoted, you've been discriminated against, you are intending to file a charge with the EEOC, let me just walk you through a couple of my notes regarding the EEOC and that process, okay? First and foremost, the EEOC is currently closed as a result of the government shutdown. So they are not doing new intakes, right? If you go that route, which is the sort of mass market consumer route, okay, where you submit an inquiry and then they schedule you for an interview and then they help you complete a charge of discrimination, that process is on pause because of the government shutdown. So there is no way for you to get your charge filed if you go through that route. At this point in time, given the shutdown, your only viable option for getting a charge of discrimination filed with the EEOC is to get your own lawyer and have a lawyer file that charge for you. I have said this before and I will say it again, okay? If you have a strong, compelling claim for discrimination that needs to flow through the EEOC, you should be able to find a lawyer who is willing to do that for you as part of a contingency fee representation agreement, okay? I see a lot of lawyers and law firms out there that charge folks $300, $400, $500, $600 to prepare an EEOC charge. And these lawyers always get defensive whenever I look sideways at that. But from a business standpoint, okay, if you have a legitimate case and I have a 40% contingency fee on that case, my firm is happy to prepare an EEOC charge as part of that process, okay? But then again, we look at cases differently than a lot of other law firms in this space. You have to be careful of law firms in this space that are settlement mills. And by this space, I mean employment discrimination, retaliation, sexual harassment, etc., right? There are a lot of lawyers and law firms that handle these types of claims, but only pre-suit, only through the EEOC process, okay? We look at them differently. We select cases that we're willing to invest in and we're willing to actually litigate these cases and wait 6 months, a year, sometimes 2 years worth of work before we get paid on the case, okay? So if you have a strong claim, you should be able to find a lawyer who's willing to represent you on a contingency fee basis. And a lot of people, get up in arms and they say, well, I have a strong case, and you wouldn't take my case, JP. Well, your case is either A, not strong enough, or B, we think you're a problematic client, or C, you are in a different jurisdiction where we either don't practice, or for us to take a case there would require tremendous additional costs and expense. You have to understand, folks, if we're willing to litigate a discrimination case, a retaliation case, we are routinely spending $15,000 out of pocket on hard costs, plus all of the attorney time. You think that attorney time is free? Okay. No, these are highly trained, highly experienced, well-regarded, highly reputable lawyers, right, in our firm who do this work. That's not free. I'm fronting that, okay? So yes, I'm very selective about cases, but if you have a real case, you should be able to get a lawyer to prepare a charge for you with the EEOC on a contingency fee basis. But let's talk about the EEOC and what your reasonable expectations should be, okay? I see so many people who show up every day and they're talking about additional evidence they want to put in front of the EEOC, right? They show up and say, well, the EEOC doesn't have the full picture. They don't have all the documents. I have thousands of pages of this and that, and I have these additional witnesses, and I want to make sure the EEOC has it all. Stop. That is not what the EEOC does, okay? The EEOC does not decide your case. The EEOC might take, right, one case out of every several thousand cases that flow through the EEOC. They might take one case that they choose to prosecute, okay, where they choose to step in and represent the plaintiff, right? The cases that they choose to pursue tend to be very big ticket cases, have a lot of plaintiffs, are a hot button social political issue, right? That the current administration backs, okay? What is the EEOC potentially going to take in the current administration and political climate? I could see the EEOC taking cases involving discrimination against men, or involving discrimination against white people, or discrimination against Christians, right? I could see the EEOC pursuing those types of cases. But again, it's only going to be one out of every several thousand, all right? So for everybody else who goes through the EEOC, what is the entire purpose of the process? The entire purpose of the process is just checking that box, saying, yes, I filed a charge with the EEOC. The EEOC was set up, okay, to prevent people from being able to go straight to court, all right? It was a legislative compromise. And the goal there was attrition. The goal there was, hey, we're going to set up the EEOC as this barrier, as this obstacle. And if people don't go through that process, they'll lose their claims and they won't be able to file a lawsuit. That's the purpose of the EEOC, okay? So in 2025, the EEOC serves no purpose whatsoever other than being a barrier to getting into court and being a box that you have to check. So if you are one of these people who think you need to put everything in front of the EEOC, why? What are you doing that for? What are you doing that for? You think the EEOC is going to give you a gold sticker? Okay. No, they're not going to do shit for you. They're just going to issue you a right to sue letter. Okay. Then you get into mediation. Okay. And I've talked about this before. Just say no to EEOC mediation. Unless you want $2,500, $5,000, maybe $10,000. I see it all the time where people have legitimate cases, okay? These are cases that if you litigate are going to be worth six figures, right? At least $100,000. And they're represented by a settlement mill, and they go to EEOC mediation and they settle their case for $5,000. If it's a really good case, they settle it for $10,000. And then on the back end, we hear from these people and they say, oh my goodness, I didn't know, is there any other option here? No, if you go that route and you go to EEOC mediation with a settlement mill lawyer and with an EEOC mediator, they're going to put tons of pressure on you to accept a dog shit settlement, okay? Is your case only worth $2,000, $5,000? Maybe if it's a crap case, but if it's a real case, it's likely worth way more money than that. I've said it before. EEOC mediation is like the Dollar Tree. If you go to the Dollar Tree, you are going to get cheap shit. If you go to EEOC mediation, okay, you are going to get very little money, right? That's what your expectation should be. So stop expecting to get something out of the EEOC process, and stop thinking that the EEOC is going to advocate for you or do work for you or be on your side of a case. They are not. They are not. They are solely there to give you a right to sue letter. But it goes beyond that, okay? Consider for a second the value or utility of putting a whole bunch of evidence and information in the record at the EEOC stage, right? Let's consider that. I've talked about this before, okay? I've talked about this before, and what I'm trying to do is put it into this video so I hit all of my major current EEOC points in one video. Is it beneficial? Is it really beneficial for you to put everything in the kitchen sink in your EEOC charge? Again, I see people saying, I need to supplement the record. I need to give them this more information. For what practical purpose? They're not going to do anything with it. Okay? They're not going to do anything with it. And in fact, you actually put yourself at a disadvantage if you put all of the facts that you know and all of the evidence that you have in your EEOC charge and into the EEOC record. You put yourself at a disadvantage, and I'll tell you why, okay? The defendants in these types of cases, all right, HR, their corporate lawyers, big law, etc. In most of these cases, they are going to lie, okay? In most of these cases, they're going to lie because, sometimes it's just bold-faced, right? They're just lying through their teeth and they know it, okay? And other times, higher-ups in HR, outside counsel, are getting a version of events, right? They're getting a version of events from the folks who are on the ground and in the trenches and in the day-to-day and who are involved in the situation. So obviously, they are getting the rose-colored version of what happened. They are getting the pro-corporate narrative of what happened. And frequently, that's a bullshit story, right? That's a bullshit sequence of events. It's totally fabricated. It's false. Sometimes the higher up in HR know. Sometimes outside counsel know that it's bullshit. Other times, they're just being misled, right? The actual people who are involved in the day-to-day are feeding them a load of bullshit and they're running with it as their defense, okay? You want to lock these people in on their narrative. You want to lock these people in on their narrative early in the case, okay? You can actually exploit the EEOC process to your advantage by doing the following. You file a charge of discrimination, but you make it very basic, right? I worked at this company. This was my role. These are my dates of employment. Here's who discriminated against me. Here's what they did. I want damages under the following statutes, right? Keep it very basic, just the facts, because what that does is that allows the company and their outside counsel, okay, to come in and give you their narrative of what happened, right? They're going to give you their version of events, but it is far preferable that you bait them into it. You invite them to give you their version of events without putting all your cards on the table, because they're gonna fucking lie, okay? It's like we've done this hundreds of times, okay? We've done it hundreds of times. A liar's gonna lie, okay? These people are halfway crooks. They're not smart enough to be whole way crooks, okay? They're gonna fucking lie and they're gonna be sloppy about it. Bait them into it. Let them do that, okay? Don't fill in all the gaps. Don't fill in the entire picture for them. Just give them the basics. Give them the basics, okay? Let them come in off the top rope and say, it's bullshit. This never happened. Here's our story. And then in your back pocket, okay, you've got all the real facts. You've got all the witnesses, witness statements, key documents, etc., right? Say you have a smoking gun document. Say you have a smoking gun email, whatever that is, right? An email or a text message that is, incredible for your case, proves your point, right? Say you have that. Don't out with that. Don't out with that until you get into litigation and discovery. Let the other side, let the company and their outside law firm come in off the top rope in the EEOC process and say, you're a bullshit liar and it never happened. There was no discrimination. There was no retaliation. Let them lie on paper and be locked the fuck in on their statement, okay? We have had so many cases where the company's position statement in the EEOC was golden for our case because we had other evidence that showed they were clearly lying through their teeth, right? And then that creates, right, credibility, pretext, everything else, go to trial. So the moral of the story is when it comes to the EEOC process, one, don't expect shit, okay? Just expect a right to sue letter. That's it. Expect the right to sue letter and do the absolute minimum that you have to do in order to get that right to sue letter. Because one, that is more efficient, and two, that is more strategically advantageous if you were going to litigate the case and invest the time, the money, the resources, the effort into getting reasonable value on those claims. That is how we get down. Jonathan Pollard, have a good day.